Okay, thank you for joining the Dental Board meeting of California. Good morning. My name is Dr. Lilia Larin. I am president of the board, and welcome back to the open session of our meeting. The closed session has now concluded, and we will proceed with the open session. Today is Thursday, August 13, 2026. This board meeting is being held via teleconference with the disclosed in-person location available for board and public member participation. For all those who wish to participate online, please log on to the WebEx website provided on the posted agenda for this meeting. Instructions to connect to the meeting are provided on the agenda. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. This is an official business meeting of the Dental Board of California. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. Please be mindful of the words and tone you use when sharing your thoughts. We understand that issues discussed here may be deeply personal or frustrating, especially when we find ourselves on opposite sides of an issue. But even in disagreement, we ask that everyone engage respectfully. Let's aim for a dialogue that is constructive rather than contentious. Please remember that every process, discussion, and decision undertaken by this board is grounded in our mission to protect consumers. That remains at the heart of all we do. The DCA moderator will explain the process for providing public comment shortly. For individuals participating via WebEx, when called upon, the moderator will give individual permission to unmute themselves. They will have 2 minutes to make public comment. The moderator will audibly announce when 30 seconds remain to conclude the public comment. After 2 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. We ask all speakers to please stay on topic and not repeat testimony already provided. If you agree with the testimony already provided, please just state your name that you are in support of any comments that previously provided. I would like to ask the DCA moderator to please explain how public comments will be taken during this meeting. DC moderator?
This is the moderator of the meeting. For purposes of today's meeting, when the board president opens public comment, members of the public who would like to provide public comment at our DCA location in Sacramento can approach the table and microphone at the front of the room. For those joining via WebEx, when the board opens for public comment, I will announce that a comment period is open. Members of the public will then be able to click on the hand icon to raise their hands. Instructions will also be on the screen. Call-in users will need to press *3 to raise their hands. You will have 2 minutes to provide your public comment with a 30-second warning before your time is up. Instructions to connect to the meeting can be found in the WebEx Quick Start document that is linked on page 1 of the meeting agenda. If you are experiencing audio issues and are using a computer or mobile device, follow the call-in instructions on page 2 of the WebEx Quick Start document to use your phone as a speaker. While you are free to express criticism or negative views, for the sake of the members of the public participating on the call, please do not use profane language when making public comments to the board. I will provide a brief reminder of this approach at the start of each public comment item. Back to you, Madam President.
Thank you, DCA moderator. This meeting is called to order. There is one board member participating in the meeting remotely. Each board member participating remotely must disclose whether there are any individuals 18 years of age or older present in the room at the remote location with the board member and the general nature of the member's relationship with any such individual. Dr. Forge, is there anyone 18 years of age or older present in the room with you at your remote location?
No.
Thank you, Dr. Forge. Board members participating remotely are reminded that they must visibly appear on camera during the open portion of the meeting. If the remote member experiences any trouble with visibly appearing on camera, the member shall announce the reason for their non-appearance when they turn off their camera, such as due to challenges with internet connectivity. I will ask the board secretary to please call the roll.
Good morning, Madam President. John Deerking will now take the roll. Chan? Chan present. Chang?
Chang, present.
Chang present. David?
David here.
David present. Deerking is present. Felsenfeld?
Felsenfeld here.
Felsenfeld present. Forge?
Forge present.
Forge present. Grewal,
Grewal present.
Grewal present, Larin,
Larin present.
Larin present, Medina,
Dina present.
Medina present, Olage,
Olagi present.
Olage present, Takur,
Takur present.
Takur present, Bader Hobley,
Bader Hobley present.
Bader Hobley present, and you.
You present.
You present. Madam President, we have a quorum.
Thank you, Mr. Secretary. We will now move on to agenda item 21, Board President's Report on Closed Session Items, page 159. The board reviewed, discussed, and made decisions on proposed stipulated settlements and other enforcement matters and received advice regarding pending legislation. Are there any board member comments?
Quick question, or sorry, it's a pending litigation,
Pending.
not legislation. That's okay. We're just
Okay,
correcting.
pending litigation.
No worries.
Okay, the board reviewed, discussed, and made decisions on proposed stipulated settlements and other enforcement matters and received advice regarding pending legislative litigations. Okay, are there any in-person comments on this agenda item? Seeing none, are there any WebEx comments? Moderator, please open the WebEx to facilitate the line.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen. Or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
He's done. DCA moderators, that, we didn't have any public comments, right? I didn't hear you, I'm sorry. Did you say that?
Can you hear me?
Oh, I'm sorry, I missed that. We would like to move on to agenda item 22, report on Dental Hygiene Board of California activities, page 160. I will ask Joanne Pacheco, President of the Dental Hygiene Board of California, to provide this report. She's signing in. She's on WebEx with us today. Hello, Joanne. Ms. Pacheco.
Joanne, you are muted. Thank you. Oh, unmute yourself, please.
All right. Am I unmuted now?
Yes, thank you.
Okay. Good morning, President Loren, Executive Officer Doherty, board members, and staff. I'm Joanne Pacheco, President of the Dental Hygiene Board, to report our activities to you. Since our last report in November, we've been busy addressing the following items in addition to normal program functions. So I have 5 items to report on. Number 1, Sunset Review. The board initiated the Sunset Review process last month to prepare for our Sunset Review in 2027. Staff have begun to gather program statistics and board information to be assembled in a draft report to be presented to the board at our November meeting and ultimately the legislature by January 5th, 2027 deadline. Number 2, regulations. We continue to work on promulgating our regulations and identify the need to revise existing regulatory sections as needed. Our Registered Dental Hygienist and Alternative Practice, RDHAP, regulation package continues to move through the regulatory process. This regulation requires RDHAPs to register their dental hygiene practices with the board, whether it's a standalone clinic or portable equipment. This will assist us in the oversight of these dental hygiene practices and the licensees operating them for compliance of the law. Number 3, educational programs. Oversight of the dental hygiene educational programs continues with various changes constantly occurring, such as new program directors due to retirements or changeover, revisions in program scheduling, new faculty, and other issues. Several site visits to the dental hygiene educational programs occurred over the past few months to ensure safe practicing environment for students and operational compliance of the law. Most of the schools have some deviations from the law or Commission on Dental Accreditation, known as CODA, their standards, and they are easily correctable once identified. However, for issues that are more complex, the board provides ample opportunity once notified for the educational program to correct the deficiency for compliance. We created and approved a new dental hygiene educational program violation rubric to ensure all dental hygiene programs found to have deficiencies of the law are treated equally in determining potential penalties for noncompliance. The task force met 10 times over the past year to create this comprehensive rubric, which was approved at our March meeting and provides a score form tally of various deficiencies to provide an outcome to the board, so the board may follow to determine a penalty should the program not comply or fix their deficiencies. A higher score means a more involved or complex situation was discovered to merit the use of stiffer penalties against the program. New dental hygiene school updates. At our last report, we stated that there were 4 new dental hygiene schools in the process for approval to open in the state. We'd like to revise those numbers as there are now only 2 new schools approved by the board and scheduled to accept their first cohort in the next couple of years. The 2 schools that obtained provisional approval by the board are Stanbridge University for a San Diego area campus and California Baptist University in the Riverside area. Both will be on probation for the first 2 years once they begin their programs to ensure they're operating properly. A third school, Gurnick Academy, received provisional approval in March to open a dental hygiene school in the Modesto area. However, the board rescinded the approval in July at their request. The fourth school changed its request entirely as they underwent a restructuring and once completed will initiate a new proposal for approval from CODA and the board. Number 4, workforce shortage. We've received several inquiries from different parties regarding a perceived dental hygienist workforce shortage in California. The board has explained at our meetings and to any stakeholders who contact the board on this issue that there's a maldistribution of the existing licensee population and not a shortage. Licensees congregate in more populated areas of the state, like dentists, where there are consistent patient loads and jobs, and less in rural areas like many other professionals. The number of active licensees has remained constant over the years and has not demonstrated a workforce shortage. Other areas of the country may be experiencing a dental hygienist shortage, but not California. Number 5, personnel update. Staff. We continue to fill vacant positions as quickly as possible to address the board's work. We currently have 1 vacant position and will be losing 2 other experienced staff at the end of this month. One is retiring and the other is looking for opportunities to use her education more than the current position allows. And this concludes my report, and I want to thank you for the opportunity to share our activities with you. I'm sorry I could not be with you in person, but this is the first week of instruction and it would have been very challenging for my program. Are there any questions?
Thank you, Ms. Pacheco. Are there any board questions, discussion? I do have a question. Can you tell us the ratio of hygienists per dentist in the state?
You know, that is something that we can report out at our next meeting if you would like.
Yes, please. I'd like to see that. Do you know how many hygienists are there in California?
Again, I'll have to look up that exact number.
Oh, okay. Okay, thank you. Please, I'll
But
look forward to
I
that.
will ask Executive Officer Lum to prepare that report.
Excuse me?
I will ask Executive Officer Anthony Lum to prepare that report for our next meeting.
Okay, thank you, Ms. Pacheco.
Mhm.
Are there any, no more board member discussion? Any public questions? Good morning. Wherever, it's fine.
I am Dr. Guy Atchison.
Hi there. Nice to see you again.
Is this on? I got a green light. Okay. I guess I'd have a question for the dental hygienist board. And as a practicing dentist, we've had an extremely difficult time filling
Doctor-
hygiene positions.
Dr. Atchison, just for a point of clarification, this is the public comment period. You're allowed 2 minutes to give public comment, but this is not an opportunity to engage the presenters.
Okay. I guess my comment would be, although there's no apparent shortage in the number of hygienists, I think the work practices of the existing hygienists have changed where a significant number are part-time. And so that creates a relative shortage of hygienists. So I'd hope that they would start tracking the number of hours that the hygienists are practicing. That may help. Thank you.
Thank you. Thank you for your comments. Any more public comments?
Well, hello, good morning. Tukas Okai from the California Dental Association. Thank you for the update from the Dental Hygiene Board of California. Last November in the Dental Hygiene Board meeting materials, there was an update on the number of dental hygienists that have an active license, and CDA also ran some numbers. So based on about 70% of the dentist licensee population hiring one RDH, so those are very conservative numbers, there's still a gap of about 1,000. 988 to be specific. And we also have variance based on county because we both do, the dental board and the dental hygiene board does do it by county. Statewide, in terms of active licensees at the time, it was 32,292 licensed dentists to 21,660 licensed registered dental hygienists.
21,000 versus 37,000. Is that what you
So
said?
about 32,000 to 21,000.
And typically,
And so we see, yeah, in terms of the demand,
typically, every dentist would have how many hygienists? One or two?
these numbers are based on 70% of the DDS population hiring one hygienist. So this is a conservative approach. So if that were the case, we would still need about 1,000 dental hygienists licensed. But, and there is variance based on county in the numbers we shared. So if we're looking at maldistribution, it does also depend on county. So like for Fresno, for example, there would be a gap of 158 dental hygienists. Whereas Los Angeles County, there are more hygienists than dentists.
Thank you very much.
Thank you.
Any other public comments? Public comments via WebEx. DCA moderator, please open the public comments.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you, moderator. We'll move on to agenda item number 23. We'll move on to agenda item number 23A, status update on pending regulations, page 161, 163. I would like to hand this agenda item over to the Chair of Legislative and Regulatory Committee, Mr. David.
Thank you, Dr. Laren. My name's Robert David. I'm the chair of the Legislative and Regulatory Committee, and I, along with my good friend and board member colleague, Dr. Gruhl, comprise the committee tasked with working with board staff to educate board members on key legislation and regulations impacting consumer protection, patient access, and quality of dental care in California. Dr. Gruhl and I met with board staff on July 16th to review the regulatory update information that will be presented for this agenda item. Board staff have been extremely busy working on new regulations, ranging from updating the minimum standards for infection control for patient and staff safety in dentistry to updating how dentists apply for licensure, and even aligning dentist vaccine administration authority with the California Department of Public Health guidance. Board staff work with DCA Regulations Council and the DCA Budget Office to prepare proposed language for board consideration and to finalize the regulations for DCA director and agency approval. Board staff and Regulations Council compile rulemaking packages to comply with the Administrative Procedure Act. The packages undergo public notice, comment periods, and Office of Administrative Law review to ensure legal compliance. I'd like to ask the board's legislative and regulatory specialist, Mr. Brant Nelson, to please take us through this agenda item.
Thank you, Mr. David. My name is Brant Nelson. I am the board's regulations and legislative specialist. I am going to kind of first provide a brief intro on kind of how the board goes about making its regulations. The Dental Board develops regulations through a structured rulemaking process under the Administrative Procedure Act. First, the board identifies the need for regulatory change and drafts the required rulemaking documents, which includes a notice of proposed action, initial statement of reasons, and the proposed text. So my primary work that I spend a lot of my time doing is I work with very talented legal counsel here, not just board counsel, such as Ileana, who's here today, but also Christy Shield, who works with our regulations unit that we have within DCA, and they provide kind of a pooled resource for us to consult with attorneys who have many, many years of experience doing this, understanding what the Office of Administrative Law is looking for when we draft our regulations. And so coming from the Attorney General's office, where I spent a decade working on everything from, really high-level briefing to all sorts of trials and things, I can tell you that this is a very complex area of law. The Office of Administrative Law increasingly expects a lot of very specific kinds of input, and if they don't get that specific kind of input, you will get a very specific kind of output, and you may not like it. So we want to make sure we do things right and that we're following all the different types of underlying supporting documentation that we find when we're creating these regulations. And so once that's ready, once I meet with Regulations Council and usually a lot of the board staff and managers, when we have the text ready, the board publishes the notice of proposed action in the California Regulatory Notice Register. It's this kind of obscure website that no one really visits, but it's legally required. And so we also put it, on our website and all that during the public comment period and have everyone kind of, see it. And we have a big comment period, like 45 days where people can basically make any comment. And then after considering public comments and any necessary revisions, the board formally adopts the regulation package and votes to initiate the rulemaking. Once adopted, the board submits the complete regulatory package to the Office of Administrative Law for legal and procedural review. OAL then has about 30 days to ensure the proposal meets APA standards. So they're not judges, but they look at this for clarity, necessity, and if it's legally valid, and they approve the package, and then it's forwarded to the Secretary of State for filing, at which point the regulation becomes effective. And if that didn't put you to sleep, thank you. It's a very lengthy process. It's very complex. I actually kind of enjoy it because it's so detailed and orderly. It's kind of relaxing. So let me talk about the rulemakings that we have going on right now. Infection control is the one that I'm going to talk about first. This is our rulemaking to amend California Code of Regulations, Title 16, Section 1005, regarding the minimum standards for infection control. Infection control is one of the highest risk regulatory areas for dentistry. Modernizing these infection control standards is important because it protects patients and staff from transmissible pathogens. Dental work involves blood, saliva, aerosols, and sharp instruments. It's a high-risk environment requiring standardized precautions. Our improvements to the minimum standards for infection control reflect modern CDC, Cal-OSHA, and Cal-EPA standards. Recent proposed updates, carefully developed by both subject matter experts from the Dental Board and the Dental Hygiene Board, and one of those subject matter experts was actually Joanne Pacheco, who just spoke with us a minute ago. She was our subject matter expert for the Dental Board and helped us create this, and then she went over and is now president over there at the Dental Hygiene Board. And so we've had great subject matter experts from our board, from the Dental Hygiene Board, come together and have consensus on what these minimum standards should look like to protect the public. So what we're trying to do with these new standards is strengthen the accuracy, and there's a lot of new things that have been put into it, such as new California-approved disinfectants. We're incorporating post-COVID respiratory hygiene practices because obviously the pandemic, you might remember that happened. We learned a lot from that in terms of how things are transmitted, what works, what doesn't work. So our modern additions also include waterline management, respiratory hygiene signage, rigorous PPE requirements. We're addressing contemporary infection threats that older versions did not anticipate. And so I want to tell you that the last major update to this section was back in 2011. That was over 15 years ago. So modernizing the important minimum standards now is vital to bridge that 15-year gap and update the standards with contemporary federal CDC guidelines and address lessons learned from the pandemic regarding aerosols and water safety. So as a step, that's kind of what the update does. And that was a lot of work, let me tell you. There's like a huge book of underlying data from the CDC and all that in the last board materials. You can see all that. It's all online if you want to reference it. But the proposed text and everything got finished. And on July 6, 2026, the regulation package was submitted to the DCA acting director for review and approval. Per departmental policy, the acting director has at least 30 calendar days to review and make a decision to approve or disapprove these regulations. After it's approved there, it's the government. It gets to go on to another approval. And so it goes to the agency level, and then they'll approve it. And then after that, we can proceed with everything else we got to do. So I'll move on. That's the infection control one. The next one I have is our rulemaking regarding, where to go here? Regarding, I'm on page 162 of your board materials. Rulemaking to amend California Code of Regulations, Title 16. I'm not going to read all those numbers regarding applications for dentist licensure and fees. So this is a major update. We're updating a lot of things at the board. We are basically making sure that all of our regulations are modernized. On July 1st, 2026, board staff filed a notice of proposed regulatory action with the Office of Administrative Law. This filing, along with the proposed regulatory text, the initial statement of reasons, establishes a publication date of July 17th, and it's in the California Notice Register, and it officially opened the 45-day public comment period, which will end on August 31st, 2026. So this one is currently in the public comment period. So it's on our website. We sent out a blast message and email and everything, and we're telling everybody, hey, if you got a public comment, let us know, and then we want your comments. So I'm also saying that now. If you have public comments, please let us know. The next rulemaking that I want to report on has to do with Section 1066 regarding vaccine administration updates. This one here. These updates modernize the board's regulations so dentists deliver vaccines safely and in compliance with current laws. These updates are important to the public because they align vaccine administration with updated state authority. Recent legislative changes, AB 144, and the FDA's revocation of federal emergency use authorization require the board to shift from a federal model to a state-controlled standard for administering vaccines. These ensure regulatory consistency and legal compliance. So a lot of the authority for the vaccines now comes from California Department of Public Health. We're looking at the state rules for this, and we're updating our regulations accordingly. As an update on what's going on, the proposed text was approved by the board at its May 2026 meeting. Board staff have taken the necessary steps to begin the rulemaking process, which includes drafting the necessary rulemaking documents, notice, the initial statement of reasons, and all the underlying data and everything we need to continue working on this and moving it forward. This item, everything I've talked about so far today on this agenda item is information only. No action is requested. Thank you.
Thank you. Is there any board member discussion on this item? Mr. David?
Robert David. Have you done a fiscal analysis of the impact on licensees for the increased infection control regulations?
Yes. So we work with the budget office. DCA has a budget office that assists us with projecting what those costs could be. And so we do, if you look at the actual regulation forms that we prepare, and you can go online and see these things, you'll see that there's sections that basically ask you, how is this going to impact dentists? And that's a very important consideration because, you know, a lot of dentists are business owners. They have staff. They have a lot of things they have to keep track of. So whenever you make a regulation, you have to be extremely mindful of what you're doing and how that could cost people money. And going over this particular regulation, and you can see, you know, I even went to the point of researching at a very granular level the cost of all the different types of disinfectants. Like there's 3 different types of disinfectants you're supposed to use under the minimum standards. And I went down and figured out the price of each one down to the gallon by using a math. I don't want to bore everybody. Math, you know, statistics are kind of my thing. That's what I like to do. And so we did review this to answer your question, yes. And it was very minimal. And so we don't expect this to have a lot of the thing about the standards, the infection control standards. These are things you should already be doing. If you guys read through the minimum standards of infection control, I doubt you'll be that surprised. These are like common sense things. They're minimum standards. So, and we had consensus from the Dental Hygiene Board on this. So this is something I really spent probably, I want to say days and meetings on to make sure that we're not causing any trouble in that respect as far as costs. So I'm happy to report that it was very minimal in terms of the cost.
Thank you. Is there any other board discussion on this topic? Dr. Chan?
This is Dr. Chan. On item 2, the applications for dentist licensure, and we have an update. I assume the question about having disclosure of the status as a refugee, asylee, and special immigrant is to have uniformity across all applications. But the question is, does that apply to dentist licensure, having someone that's a refugee or an asylum or special immigrant applying for licensure in California? Does that apply to us?
You're asking if, let me make sure I get your question absolutely correct because I want to answer it correctly. Let me just first say this. The reason why we had an issue, let me just read specifically what the issue was. The housing agent, the agency which oversees DCA, which we're under, they had concerns with the text that the board's proposed language did not more clearly specify that the disclosure of the applicant's status as a refugee, asylee, or special immigrant visa holder was optional and only required if they were seeking to expedite their application. So let me clarify. We actually want to help these folks out. We want to say, okay, if you're in this category, we want to help you, but before we can help you, we have to know if you're in that category. Housing's looking at this in light of what is happening on a federal level and saying, oh, that doesn't sound good. Are you asking people this question that could implicate them in some kind of thing we don't want to get implicated in? And so that wasn't our intention. Our intention is to help everyone and move forward and get things moving. And the expediting people is kind of an existing thing that was already there. But they didn't like the way that phrasing was. And that's fine. We appreciated their input and we actually changed it and improved the text. So it is an optional question, but it doesn't pertain to, you don't have to answer the question unless you want to be expedited. So I hope that clarifies that, but they didn't like the way that phrasing was.
Well, the relevance to licensure under our umbrella is not necessarily applicable. I'm not quite sure what that means. Why is?
Well, if the question that you're asking, let me think about the question and let me know if I got it right. I think I understand what you're asking, doctor. You're saying, okay, is this question required or not? Or is it relevant? Is that what you're asking? Yeah. The question is not relevant because this question is not relevant unless you want your whole thing expedited, your application expedited. It's only relevant to that end. Does that help? Thank you.
Thank you. Any other board discussion? Do we have any in-public comments?
All right. Hello, Tuka Zokai from the California Dental Association. You mentioned, are there public comment? And the public comment period is open on the proposed fee increases. And CDA will be sending a letter, but we did want to share that, we know that the board has a data-driven approach to fee setting. And we saw that in 2015 with the detailed audit assessing the actual cost of each board's task. And we see that the current proposed regulations actually follow the same disciplined cost-based approach that was established instead of defaulting to renewal fee hikes. So we appreciate that there's this desk audit and workload analysis to inform the specific fees to processing costs. And we see that the fact that the board revised its initial proposal downward from $500 to $490 after new state budget data showed reduced costs reflects that same commitment to charging only what's actually needed. We support the board's measured approach, and this proposal, we would like to flag the future fee reviews to continue to carefully weigh unintended consequences. We see that there's the $2,000 on-site inspection fee for sedation and anesthesia permits, which members report can push providers to let permits lapse or worsen pediatric sedation access and wait lists. So there are other fees that do impact licensees that we request to also have that measured approach. And we just thank you for doing this in a very transparent way and offering the opportunity for public comment. Thank you.
Thank you. Welcome.
Oh, there we go. Okay, great. Dennis Song, oral surgeon and also liaison, California Dental Association. So just to follow up on Tuka's comments, and I respectfully agree with everything that she mentioned and very supportive of how the board can work with CDA. Just to be cognizant of the anesthesia fee model, that the permit cost relative to the reimbursement rates that are available in California is quite wide. So for that reason, it can decrease access to care. The dental license fee opens up the ability for a dentist to bill all sorts of codes to accomplish their procedures. But the anesthesia license fee is strictly only for anesthesia only. So it's not like you can go bill a whole bunch of other procedures because you have that permit. So that's just something to be cognizant of in comparison to other states, for example. So thank you.
Thank you. Any other public comments? Okay, seeing none, are there any public comments from individuals participating via WebEx? DCA moderator, please facilitate the line for public comment.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen. Or if you're an audio only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you, DCA moderator. We will now move on to agenda item 24A, 2026 tentative legislative calendar, page 164. I would like to hand this agenda item over to Chair Legislative and Regulatory Committee, Mr. David.
Thank you again. I'm going to ask Mr. Nelson to present this agenda item, which is for information only.
Thank you.
Thank you, Mr. David, Madam Board President. Agenda item 24A is on page 164 of your board meeting materials. It is the 2026 tentative legislative calendar. It is being provided for information only. It is compiled by the Office of the Assembly Chief Clerk and the Office of the Secretary of the Senate. And this calendar here gives you kind of a sense of what's going on at the legislature. And as you can see on page 166, they're wrapping up. This is their last month of hard work at the Capitol, where they're trying to get everything done. The last day for each house to pass bills is August 31st. So a lot of stuff's happening. I think there's like 1,200 different bills that are kind of moving around. And so I'll be talking about some of those momentarily, but this is for information only. Thank you.
Thank you. Is there any board member discussion on the calendar? Any in-person comments? Moderator, can you please open the WebEx for online comments? Oh, Dr. Chan, I'm sorry, Dr. Chan.
Is the discussion of Assembly Bill 1307, the handout that you gave us just now, going to be discussed now, or is it?
It will be discussed under the next agenda item.
Thank you.
Yeah, and I'll overview that for everybody, what that was and all that. So.
Are there any comments via WebEx? DCA moderator, please open the line.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raised hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you, DCA moderator. We will now move on to agenda item 24B, legislation of interest, page 167. I'd like to hand this again over to Mr. David.
Thank you, Dr. Loren. This is Robert David again. I'm chair of the Legislative and Regulatory Committee. I might add, we have two legislative experts on staff. We've got Mr. Nelson as well as Mr. Dockery. So we're doubly blessed in this area. My colleague, Dr. Gruhl, and I met with board staff on July 16th to review the legislative information that will be presented for this agenda item. For the 2026 legislative session, a total of 1,798 bills were introduced in the California legislature by the February 20th deadline for bill introduction. There were 1,237 assembly bills and 561 Senate bills. There were also roughly 300 active two-year bills that were carried over from the 2025 legislative year into the current session. Since May, some bills have died and some have been amended. Out of the frenzy of legislative activity, board staff have carefully focused on legislation that remains of interest to the board. Board staff have prepared a memo that organizes the bills into three categories. First, the memo overviews the 2026 legislation where the board took support and watch positions. The memo provides the status of each bill and is provided for information only. Second, the memo overviews two-year bills of interest where the board took various positions on bills introduced in 2025. The memo also provides the status of each bill and is provided for information only. Third, and most importantly, this will be the meat of the discussion today, the memo focuses on 8 2026 priority bills for either information only or for discussion and board consideration. And I will pass this on to Mr. Nelson to discuss. Thank you.
Thank you very much, Mr. David, Madam Board President. And with Mr. David's overview of this agenda item, where Roman numeral 1 and 2 are information only, but we're on now, I want to focus this on page 169, where you see Roman numeral 3, where it says 2026 priority legislation for discussion and board consideration. And just as a preliminary housekeeping item, I just want to point out that there is a what's known as an RN. It's basically kind of a working document that's sent out when people are negotiating or looking over changing amendments to a bill. For AB 1307, which is E under 2026 priority legislation here, there is a copy of this RN provided in the back. So if you're sitting behind me right now, you can go to the back, very back up against the wall. There's a big stack of the documents there if you'd like a copy to reference, but we'll be going over it verbally. I also provided a copy of that to the board members, and we will be posting that on our website. It may take a little bit of time, but we will be putting that up. We received that very recently, and so we wanted to make it available as a courtesy and just as an open kind of meeting consideration to make sure that we have that document available since we're discussing it, but it was not included in the board materials due to us receiving it so soon. With that, I will go over our bills here, the priority bills. There are not that many bills. There's only 8 bills, but there's a lot to discuss on these. The first bill up for discussion, well, this bill will be for information only, so there won't be any action called. Some of the bills I present today, there will be an action requested. We will be having a staff recommendation on the position, and we will request an action. But for A, Assembly Bill AB 1760 by Assemblymember Arambula, It's called, the bill title is Dentistry, and this is the Dental Board sponsor bill. This will be an information-only kind of overview. The board-sponsored bill consolidates technical, non-controversial, and substantive cleanup items approved by the board in public meetings between November 2024 and February 2026 to refine various provisions of the Dental Practice Act and ensure statutory language aligns with current regulatory standards and consumer protection needs. While these items are typically addressed during the sunset review process, waiting for the board's next cycle in 2028 to 2029 would leave in place several statutory impediments and inconsistencies for effective administration of the Dental Practice Act. This bill, AB 1760, serves as a comprehensive omnibus vehicle to optimize the board's efficiency and protect the public in the following ways. First, it resolves the dental auxiliary course implementation delays, and it also rectifies inadvertent technical errors from our sunset. Usually after a sunset bill, there's a lot of cleanup. That's common as things shake out. Also, it modernizes licensure and permits, and it also is focused on administrative efficiency. It streamlines the licensure by credential process for out-of-state dentists and removes redundant insurance requirements. This bill would reduce a lot of administrative overhead as well. For a current update to the bill, the California Constitution requires a bill to be read on three separate days in each house. The bill was read a third time in the Senate on August 10th and passed 39-0 and ordered back to the Assembly for concurrence in Senate amendments. This reflects unanimous support across both chambers. It signals the legislature's strong agreement with the Dental Board-sponsored legislation. The success has been nothing short of spectacular. Every committee and floor vote has been consistently unanimous and bipartisan. This reflects confidence in the Dental Board-sponsored cleanup package, recognition that the bill is non-controversial, technical, and improves efficiency. Again, this is an information-only item, and no action is required for the priority legislation A, and then we'll move on to B when we're ready.
Okay, we'll now move on to agenda item 24B, legislation of interest, page 167 to 11. I'd like to introduce Mr. David again.
Oh, no. We'll,
Where are we?
I'll let,
Are you going to speak on B? You're going to continue?
What I would recommend is what Mr. Nelson mentioned was some of these 8 bills are for information only. Some of them will require action. One will probably require some extensive discussion. So unless the board has specific questions or comments about an information only bill, I don't think we need comment on that. But there will be a motion and there will be action on a couple of these bills where there's an actual motion being required. So I would suggest that Mr. Nelson just proceed with the report under a Roman numeral III, and we'll stop as needed for action that's requested.
Thank you.
all right.
Very quickly, sorry, let me jump in. The board will take public comment on any items that require board action prior to the board making any such action.
Thank you for the clarification. In light of that, I'll continue to proceed, Madam Board President.
Thank
The next item is AB 1767 by Assemblymember Behrman. Public members of boards' conflict of interest. This bill is a general DCA governance bill applying to all boards and bureaus under the DCA, amending the Business and Professions Code on public members and conflicts of interest. The bill makes a clarifying amendment to existing conflict of interest law, broadening an already applied close family member concept. The bill would statutorily define close family member for public member conflict of interest purposes and required each board within the department to adopt regulations providing guidance on determining whether relationships other than parent-child prohibit service as a public member. If enacted, the bill would obligate the Dental Board and other DCA boards to develop and promulgate new regulatory packages per amendments on June 23rd. The bill was recently ordered to third reading in the Senate on August 10th. Staff recommendation is watch and action is requested.
Are there any board member comments? let's see, can you repeat what you would recommend as action?
Yes, the staff recommended, the staff recommendation is watch, and I suppose a point of clarification to the executive officer and to council as to if we need to, if we're just doing a watch, do we need to do anything? I don't.
If the board would like to change its position, then there would need to be a motion on that and a vote. And if there's any public comment, that would be helpful so that the board can take that into consideration when deciding whether or not it wants to change its position.
Dr. Felsenfeld?
Good morning, Felsenfeld, board member. In the past, when we've had legislation which is potentially changeable and may have some impact on us for the future, and we're not going to be back till November when it's all over, we have given the authority to the executive committee to make changes on behalf of the dental board. And that if something comes up on this bill that in some way makes it good or bad for us and we want to react to it, I would suggest we can consider doing that again on any bill where we're not sure where it's going, that is not clear. So that's just a thought.
Thank you. Mr. Doherty?
Thank you, Dr. Felsenfeld. Bryce Doherty, Executive Officer. That authority is granted in the board's Administrative Policy and Procedurals Manual, which is a public document that the board has approved. So that policy already exists, and that applies to any piece of legislation. Specifically, we'll get to that when we discuss AB 1307. And so we will take that into consideration sometimes, and there may be a similar recommendation today, is that a position is adopted, but providing input to the executive committee on if X, Y, or Z happens to consider X, Y, Z position. Thank you.
Okay, so we do not have to take a vote on the watch, so you can continue now, Mr. Brent.
Thank you, Madam Board President. I'll move on to C, AB 1811 by Assemblymember Rogers. This bill is called Health Professionals. AB 1811 directly updates workforce data requirements under the Business and Professions Code, Section 502, which applies to the board requiring collection of expanded data at license issuance and monthly reporting to the Department of Healthcare Access and Information, also known as HCI. It also stabilizes health professional shortage area, HPSA definitions, which can affect dental workforce and access initiatives. The bill poses minor operational impact now and is worth monitoring for implementation. Staff recommendation on this bill is watch and no, and unless the board has anything, I will proceed to the next.
Has the board already taken a position on this bill or the prior bill, 1767?
I'm currently on C, which is 1811.
Oh, I know. I'm also asking about this one and the previous one, just to be clear in my mind.
Yes, the staff recommendation is watch and action is required because we have not taken positions on these bills yet.
Oh, okay. So yes, then you do need to take a vote on 1767. Sorry, I know I'm skipping back one, but I thought that was presently the board's position, but in order to take a watch position, then yes, you will need to vote on it.
We're back at 16.
But we can finish 1811, but before we move on to the next one, I'd like to backtrack to 1767 just to kind of tie up the loose ends on that one, please.
Do we have any discussion on 1811, the board members? You have a motion? I'll make a motion to watch.
On which bill?
1811. Watch.
Okay.
It was proposed by the staff to watch this. We have a first and a second. Do we have any comments in person? Please open the WebEx, Mr. DCA moderator, for online comments.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. We will now take a vote. Mr. Dearkin, Board Secretary.
Thank you, Madam President. We're voting on agenda item 23, small numeral, Roman numeral 3B, AB 67.
I'm sorry, I did not mean to.
Are we doing 18?
1811, we'll finish this one and then we'll go back. I'm sorry, I did not mean to mess everybody's concentration up.
Okay, agenda item 23, small Roman numeral 3B, AB 1811, related to health professionals. I'll now take a roll call vote. Chan, aye. Chang, aye. David,
aye.
David, aye. Deerking is aye. Felsenfeld,
Felsenfeld, yes.
Felsenfeld, aye. Forge,
Forge, aye.
Forge, aye. Grewal,
Grewal, aye.
Grewal, aye. Larin,
Larin, aye.
Larin, aye. Medina, aye. Olage,
Olagi, aye.
Olage, aye. Takur,
Takur, aye.
Takur, aye. Bader Hobley,
Bader Hobley, aye.
Bader Hobley, aye. And you,
Aye.
aye. Unanimous, Madam President.
Thank you. Motion passes. So we're going to go back to AB 1767. There was a recommendation by staff to take a watch on this position, on this AB 1767.
You motion to watch.
You motion to watch. Any second? Dr. Thakur, second. You have any board member discussion? Do you have any in-person comments? Seeing none, Mr. Moderator, please open the lines for comments online.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you very much. Please, Mr. Deerkin, Board Secretary, take a roll.
Thank you. And just a point of clarification, on AB 1811, I indicated it was capital letter B. It is actually capital letter C. So now we are at 23, Roman numeral small 3 B, AB 1767, related to public members of boards and conflicts of interest. Chan, aye. Chang, aye. David,
aye.
David, aye. Deerking is aye. Felsenfeld,
Felsenfeld, aye.
Felsenfeld, aye. Forge,
Forge, aye.
Forge, aye. Grewal,
Grewal, aye.
aye. Larin,
Larin, aye.
Larin, aye. Medina, aye. Olage,
Olagi, aye.
Olage, aye. Takur,
Takur, aye.
aye. Bader Hobley,
Bader Hobley, aye.
Hobley, aye. And you,
Aye.
unanimously passes, Madam.
Thank you. Mr. Brandt, you can continue.
Thank you, Madam Board President. I'll move on to D, AB 1952 by Assemblyman Berman. This is a bill titled Dentistry Dental Hygienist Licensure. And this bill is something that is being provided for information only. We have just kind of some things to share about this. This bill is dead. It was sponsored by the California Dental Association and aimed to increase access to oral health professionals by creating an alternative competency-based licensure pathway for internationally trained dentists to become licensed or registered dental hygienists without completing a full accredited dental hygiene program. That bill's dead and is just being mentioned for information only. And with your permission, Madam Board President, I'll move on to the next item.
Thank you.
The next item is AB 1307. And I have a lot to discuss on this particular bill. So fasten your dental board seatbelts. We're going to get into it. I'm going to first kind of talk about just to kind of roadmap. I don't usually talk this much about a bill, but I think that it does require a lot of overview so that we kind of correctly articulate what's going on. First, I'm going to talk about the intent. What's the bill trying to solve? The background of AB 1307 and the history of this Mexico pilot program, the eligibility of participants in the program, and how we are ensuring the 30 dentists that are participating are providing not just access to care, but quality care. And then lastly, I'll go over the current legislative situation on the ground and the recommended position for the board. First off, I just want to talk about the bill's intent. The bill's intent is to solve a public health crisis in underserved Latino communities. I think one of the best ways for me to objectively overview this public health crisis is by using statistics and sharing the findings of some key studies. Just this year, I personally completed the Stanford Medical Statistics Program, which rigorously prepares you to analyze, interpret, and visualize health data. There's a certain literacy needed to evaluate medical literature, or if you're designing clinical trials, or if you're applying robust statistical methods to real-world problems. And so the information I want to initially share here is intended to objectively convey the severity of the situation in California's underserved settings and why this pilot program that brings 30 dentists from Mexico to work in California's underserved settings is important to understand thoroughly. AB 1307 seeks to address persistent barriers to dental care in California's underserved communities. These communities frequently experience limited access to dentists who speak Spanish and who understand relevant cultural contexts, particularly in federal designated shortage areas and at community health centers. According to a study by Health Force Center at UCSF, California faces severe geographic and access and a maldistribution of dentists, which is a public health crisis. At the close of 2025, the state had 565 federally designated dental health professional shortage areas. It is estimated that 3 million residents live in these areas, with only about 36% of dental care needs met. Available workforce analyses conducted at George Washington University show that Latinos, who make up approximately 30.9% of the state's labor force, account for only 4.2% of dentists. My survey of earlier California-specific research documented longstanding underrepresentation of dentists of Latino origin relative to population size. According to California DHCS utilization data, children in these underserved communities face challenges. Statewide data indicates that roughly half the children enrolled in Medi-Cal receive an annual dental visit, well below longstanding goals. When routine dental care is unavailable, patients often turn to hospital emergency departments for non-traumatic dental conditions, such as tooth pain, abscesses, advanced decay. California experiences tens of thousands of such emergency departments visits each year. These visits are frequently more costly than preventative or routine dental care. Counties with fewer oral health providers tend to show higher rates of these preventable emergency visits. Research shows that when patients and providers can communicate directly in the same language, outcomes related to understanding, trust, satisfaction, and engagement in care tend to improve. Systematic reviews and studies of Spanish-preferring patients have found higher trust scores and better communication when language concordant providers are available, compared with reliance on interpreters or language discordant encounters. These principles of clear communication and cultural alignment are relevant to dental care, where patient understands the treatment recommendations, follow-up, and prevention. So I'm kind of hoping that that kind of illustrates kind of the issue. There's places in California, and it's not just dentistry, there's other things as well, where very sadly people cannot get any care. And it is objectively a very serious crisis. And so I want to also kind of go into the background of AB 1307, because this is not a new program. It's actually something that's been on our books for quite some time. The original licensed physicians and dentists from Mexico pilot program was established by AB 1045. That was back in 2002. So I was a junior in high school. This program already exists on the books. So it basically already authorizes limited 3-year practice for up to 30 physicians and 30 dentists from Mexico. So there's a corresponding physicians from Mexico thing going on. And the implementation, I mean, nothing has happened because the implementation was delayed for more than 2 decades because the necessary non-state funding was not secured until approximately like 2018 to 2020 or so. And when those resources came available, priority was given to the physician component. So as a result, the dentist portion of the original pilot never really launched. The physician side of the program has advanced. Mexican physicians began serving patients in 2021 at participating community health centers. A multi-year evaluation by the University of California, Davis for reducing health disparities, their final report in 2025, found positive results, including improved access, stronger cultural and linguistic alignment with patients, increased patient trust, and higher detection and management of chronic conditions, Subsequent legislation has continued and adjusted the physicians program. AB 1307 updates and restarts a limited dentist pilot under a comparable framework. There's a small number of 3-year non-renewable licenses. They practice in restricted qualifying federal health centers and shortage areas specifically. They'll be using primary source verification of Mexican credentials. So we'll be looking at their credentials, their primary source of those documents. They have to have English proficiency. They have to have peer review and formal evaluations. And this is all funded by philanthropic sources. None of it is from the state fund or the dentistry fund or any of that. The bill is intended to test whether this approach can help improve dental access and culturally and linguistically appropriate care for underserved Latino communities. And so next, now that you kind of have a sense of like the public health crisis that we're dealing with in these underserved Latino areas, and that you also have a sense of kind of the background of the bill, I want to talk about the participants, the kinds of things that we can expect. Because the dental boards, if you go to the dental board's website, we have a mission statement and we have a vision statement. And the vision statement says, the Dental Board of California will be the leader in public protection, promotion of oral health, and access to quality care. So when we think about providing access to care, it's quality care. And so we want to ensure that aspect, the qualitative aspect of what's happening. So if you go to, if you want to follow along, you can, or you can just listen in. If you go to page 201 of your board materials, I guess it starts technically at 200, but then it gets cut off. I'll talk about kind of the eligibility requirements. So all 30 dentists that are coming into this program, here's the criteria they're going to have to meet. They have to graduate from a dental program accredited by either Consejo Nacional de Educación Odontológica, and if you can tell, I can't speak Spanish. So bear with me. I tried to learn, but it's hard. And I'm still trying to learn. So this is the main, these accreditations are really important, and they're recognized markers of educational quality in Mexico and are endorsed by the Consejo para la Acreditación de la Educación Superior. So that's their main accreditor. They have to be certified by ADM, which is the National Written Clinical Competency Examination covering oral diagnosis and treatment and planning, and periodontics, direct restorations, indirect restorations, endodontics, and removable prosthodontics. So they really have a lot of this. You can tell, like and I did the research. These are the high end. These are the authoritative credentials that you'd be looking for if you're assessing whether this person from Mexico is a dentist that, according to Mexico, has the necessary credentials to practice. They have to hold an active license to practice dentistry issued by Mexico's Secretary of Education. They have to demonstrate English proficiency by achieving a minimum score of 85 on the test of English, and or they can do the TOEFL, which is, I'm sorry, that is the TOEFL. They have to score 85 on TOEFL or 350 on the OET, which is another type of English assessment. They have to satisfactorily complete an orientation program connected to the former license of physician. So actually, things are changing in real time. So this is not really, some of these things we'll go over. I'm going to go over after this, after the eligibility requirements. I'm going to go over how things are changing in the bill, but I just want to kind of give an overview first of what's required. So dental protocols, community clinic history and operations. They have to go over all these things as part of their orientation program. And then participants, I'm jumping to page 202, participants who practice at an FQHC that operate in a federally designated health or dental professional shortage area, they have to maintain quality assurance protocols. They have to basically work in those specific areas. They can't just go anywhere. You heard earlier on the dental hygiene board's kind of check-in with us. They were talking about how there's a maldistribution of dental hygienists. Well, there's a maldistribution of dentists also, as you know. And so the goal is to have these people come from Mexico and not, maybe work in Newport Beach. Maybe they need to work in an area where there's, a need. And so by requiring them to work at the FQHCs, that does make sure that they're in the place where they need to be, but also the FQHCs have their own kind of accreditation. And you can see that here on page 202, where there is dental quality assurance protocols. They are accredited by the Joint Commission Accreditation on Ambulatory Healthcare, the National Committee for Quality Assurance, and employing FQHCs must continue their existing federal peer review process. There is a process. The FQHC must work with dental school in California the FQHC must work with a dental school in California approved by the dental board to conduct 10 secondary peer reviews of randomly selected patient encounters with each participant per 6-month period and transmit complete records of those encounters to the dental school. So there's ways that we're checking in and seeing, okay, how's this going? And so there's, with that in mind, that's kind of the eligibility requirements. I'm kind of overviewed them quickly, but I also wanted to, let me see here, go back. I also wanted to go over kind of the current legislative situation and talk about the board in an implementation perspective. In terms of funding and operative date, all costs of administering the program must be fully paid by philanthropic foundations. The program would become operative 6 months after the board receives written confirmation that funding has been secured. There's some changes to that aspect, which I'll talk about in a little bit. In terms of oversight, very importantly, the board retains authority to issue license, verify credentials through primary source documentation, conduct criminal background checks, and exercise disciplinary authority under the Dental Practice Act. We're not losing any of that authority. Participants remain subject to all applicable California laws and board regulations while practicing under the limited license. For the fiscal impact of on this bill, as in print now, the board reports an estimated non-absorbable fiscal impact of $350,287. That is our fiscal impact, but that could change too, depending on how the bill is amended. And so I'll kind of talk about the legislative history now. At its May 2025 meeting, the board did vote to take an oppose unless amended position on AB 1307. And we had concerns, and board staff met with Assembly Member Avila Frias's office and the bill sponsor to address the board's concerns. Based on the July 8, 2025 amendments to the bill that addressed the board's concerns, the board sent a letter on July 9, 2025, withdrawing its opposed unless amended position. On June 3, 2026, AB 1307 was amended in the Senate Committee on Business Professions and Economic Development by the bill author. On June 9th, 2026, the board sent a letter of concern and technical assistance to the bill author and the Senate BPED Committee, which is the Business Professions and Economic Development Committee, outlining several issues with the June 3rd, 2026 version of the bill. A copy of this letter was also sent to the DCA Division of Legislative Affairs. While emphasizing the board's policy objective was expanding access to dental care in underserved communities, the letter also emphasized board operational and consumer protection concerns. The letter sets forth 6 critical needs essential for consumer protection and 8 additional recommendations as suggested improvements to assist the board in implementing the pilot program. And I actually provided a copy of this letter because I want you to see our advocacy and what we're doing. If you go to page 207, there's a copy of the letter there featuring first the critical needs. And I'd like to just review this briefly. So the first thing we basically said after the bill was amended is, and this is an opportunity for us to put on the record our concerns and establish what is important to us. And so you can see here, this particular letter says under critical needs, fingerprinting and ongoing background checks. We wanted to emphasize very strongly and strategically that we want to keep our criminal background monitoring requirements. That is in the bill. That is something that we have ensured. If you look, let me pull up my notes real quick. So fingerprinting and background checks. Because the bill issues a license, the board's existing general authority under Business and Professions Code Section 144 and the related Department of Justice fingerprinting and criminal history provisions that apply to dental board license applicants is in effect. The current bill text does not exempt the pilot program applicants from these standard requirements. Both items are, so basically this is something we got, number one. Number two, we resolved two. There was an issue with how we were going to resolve the SSN ITIN requirements. There was an issue with the enforcement authority and due process, which we determined is sufficiently covered under AB 1307. Suspension or revocation of a license issued under the program shall be governed under Article 4 of the Dental Practice Act. And so Article 4 is the board's standard disciplinary and enforcement authority, so that's in the bill. The commencement of the 3-year license period, all these things pretty much we've been discussing with the author's office at length. And then so number 4, the commencement of the 3-year license period, we straightened that out, made sure that it's clear that it's a 3-year license period. The regulatory authority under 5, that's something we're still working on. We want to make sure that we preserve the board's ability to make regulations and administer the program appropriately. So that's kind of something I would flag, as we have not quite totally, I think, put that issue to rest. Number 6, the funding before implementation. I'll talk about that more in a minute, but that is something that we've been discussing. The additional recommendations are things that are they're important to the board, and I don't think there's anything of particular interest to point out there. These things we've all just thoroughly exhausted and discussed with the author's office, and I'm happy to answer any questions on the letter if necessary. But there was under 8 a program evaluation that in the most current version of the bill, the RN that I handed out and it was available in the back of the room, that particular evaluation has been removed, and it probably will affect the way that we assess the economic fiscal impact of the bill. So as you can see, this was kind of our letter that lays out all the problems we may have with the bill and how to improve it. It's a technical assistance letter meant to assist the Senate Business, Professions, and Economic Development Committee, as well as the author's office, to ensure that we are protecting the public and doing our role as stewards of the Dental Practice Act. And so that's kind of where, once we sent out this letter, and now I'm going to jump back to where we are now. So AB 1307 was amended again on July 1st, 2026 to address issues raised in the Senate Business, Professions, and Economic Development Committee. The board is continuing to work with the bill author, sponsor, and committee on further amendments to address board concerns. So what we have here and what I handed out is this document here. This is known as an RN. It's a draft of amendments. This has been approved by the bill's sponsor and the bill's author's office. It has not been approved by anyone else. It's just something that we've received from them, and we have permission to distribute as kind of a way to discuss these amendments. And so this is kind of the working draft that we currently have. And as this proceeds, what's interesting is this bill is currently on hearing today. This particular bill is in Senate Appropriations today for hearing, and it's also on the suspense file. So we're going to see what happens. We really don't know what's going to happen as far as what's going to happen in terms of the amendments. We'll know more as time goes on, but I wanted to provide kind of a snapshot in time of where we're at. In terms of this document that you see here, there was 20 amendments, and a lot of these changes are like minor things, but I would say that I reviewed all 20 very meticulously along with board staff, and we only have, in my mind, and let me know if anyone wants to discuss any of this as well, but the license fee is one. So the 10th amendment on page 4 in line 29, it sets the license fee at the lesser of $957 or the reasonable regulatory cost of administering the program. That's vague and ambiguous. I don't quite understand the way that's written. I think board staff would like to see that revised to be more clear. And then the only other amendment I think that I wanted to flag as a potential discussion was number 14, which says it adds a new requirement that a participant must pass 8X, the dental examination, before practicing. So they're saying in addition to the criteria of requirements that you need to do to go through to participate in the Mexico pilot program, you have to also do the 8X. And so one of the concerns is, making sure these people have appropriate clinical ability, that they can do the care. And 8X is one of the tests that we look to assess that. And so they want to, the author's office and the bill sponsor do approve of including that amendment, but we do not know for sure if that will be included in the final version. And so I wanted to point that out. Lastly, I think there was one more thing. I just got this actually not too long ago, so I've been reading this obsessively, and I feel like there's only two things after spending so many hours on this. It's kind of surprising. Page. Oh, let me go to just one moment. I think that might be, and also, yeah, I think those were the two main things I wanted to discuss. There may be another thing. Oh, possibly there's legislative intent language that I have an issue with. This the 20th Amendment deletes the prior operative date provisions and inserts a new legislative intent language requiring the board to implement the program within 6 months of receiving $200,000 in philanthropic funds and authorizing emergency regulations. So basically, they're allowing us 18 months for an effective period for regulations that are necessary. But there's some intent language here that states the new language expressly states legislative intent that the board administer the program without adopting regulations. And we will need regulations. That is something we will need. I've talked with our legislative counsel, DCA, about this, and it's something that is pretty standard. We do have regulatory authority, and we need to have that. And so putting that in the bill like that is not something that board staff see as a thing that we could be okay with, but we would like to see that changed. And so I've kind of given you now an overview of kind of where the bill is. We don't know what's going to happen once it comes out of committee. And so we're kind of in this wait and see period, but I wanted to kind of articulate for you why this bill is important. And while it is a solution to something that we all care about, which is access to care, we want to make sure that that access to care is quality. Those 3 million people that live in these underserved settings, it matters to them that the quality of care is good. And I also want to just lastly kind of talk about CODA, because I think there is kind of this consideration with CODA. Like, how is this a shortcut around CODA? And it's not. This program is not a shortcut to the CODA requirement for full California dentist licensure. The program is limited, 3-year, non-renewable license with a cap of 30 participants. Practice is restricted only to FQHCs. It does not waive or replace CODA. The structure is consistent with the legislature's broader approach of maintaining CODA-level educational standards for unrestricted licensure. It's a carefully limited pilot program to address access needs in underserved Latino communities. But the board needs to ensure, as the bill is finalized, the amendments balance increased access to care with quality of care. We want to promote access to not just care, but quality care. And so for this reason, we feel, after a lot of careful thought, that our position should be watch. And the reason why actually ties back to something that Dr. Falsenfeld was mentioning earlier, our interim authority as we move forward. And I would actually invite, I've been talking about this with the executive officer, and he'll touch on this too, but if we're in a watch position, it's kind of like a neutral fighting position. It's kind of like, okay, I don't know what's going to happen. Maybe something good's going to come my way, or maybe I need to block something, you know? And so being in a watch position really puts you in the best position to kind of address that in my mind. So hopefully, being in a watch position and then seeing where the amendments go, we can then adjust accordingly, and see how it goes. But that concludes kind of what I have to say about it. I'm sorry for talking for so long. And I invite the executive officer if he has anything he'd like to add to this discussion.
Very quickly, let me just say that, yeah, I agree with the watch position perspective, but at the same time, if you actually have, you have 2 weeks until the end of the legislative session. So if you actually feel like the board wants to say, we want these changes, watch is not going to do it. So you could do a support if amended.
Yes.
Yeah, so, anyway, but let me know if you guys have questions, but I just wanted to kind of put that out there so that it's just something to think about.
Mr. Doherty?
Yeah, good morning. Bryce Doherty, Executive Officer. I'm going to let Brant take a big, deep breath. Excellent overview. As you can tell, this has been a very, very important issue and piece of legislation for the board. Brant, in 27 minutes, just gave you an 18-month overview of what has transpired with regards to this bill. I have nothing really to add, but I did want to punctuate a couple of things. I've been the principal negotiator with the author's office, with the Senate Business Professions and Economic Development Committee, with the sponsors on your behalf. We did have a meeting with the committee, with the sponsor, with the author's office, with board staff, and with your executive committee, which included Dr. Loren and Ms. Olagi, on June 12th to walk through all of the concerns that was raised in the letter of concern and technical assistance. Let me just kind of handicap this for everybody. I think we have gotten, 90% of what it is we were asking for in the bill. In legislative speak, that's pretty darn good. In legislative speak, if you get half of what you want, take it. So we can walk through a couple of the issues that we have flagged that Mr. Nelson has pointed out, but I also want to point to one specific item in the bill that was a positive, and that was a new issue that was addressed, and it was an issue that was brought up by Madam President, and something that was elucidated for us yesterday with regards to the 8X presentation. And we specifically asked, and I'm very glad that they covered that issue. So in the mock-up that you have, the RN, which is called a routing number, which is legislative council language of the mock-up of the bill. And this is the last phase of what the language looks like before what we do in legislative speak is cross the bill before the bill appears in print. So if you skip forward to the first 4 pages of the mock-up, those just describe what the amendments are. If you go to the actual parts of the bill where you see the strike-throughs and the additions, that is technically, if all of these amendments were taken, that is technically what the bill is going to look like. So for purposes of this discussion, we felt it was possible, and we had explicit approval from the author's office. Not only did we have approval from the author's office to share this RN with the board and to share this RN with the public, the author's office encouraged us to do so. So we're in this kind of unique, what we call in legislative speak, a wobbler position, where we have the bill in print. What has happened with the bill is the bill as amended and as it left the assembly was similar but different than this current version of the bill, because the way they constructed the language of the bill was they completely repealed the existing licensed dentist from Mexico pilot program that had been on the books since 2002, and they replaced it completely with this new program. So we had to do our due diligence and take a de novo look at the bill and to do a de novo analysis on the bill. This was prior to me and a couple board councils ago. Last year, the board, based on your opposed unless amended position, negotiated with the author's office, completely rewrote the bill to something that looked very, very different than what it looked like when it left the assembly. Then the bill went over to the Senate, and that's why we have, two bodies in the legislature, right? So the checks and balances occurred. The Senate wanted to go back to more of the version of the bill as it left the Assembly. So honestly, since for the last 2.5 months, board staff at the program level, Mr. Nelson, myself, our Assistant Executive Officer, Mr. David, Dr. Graywall, Dr. Loren, Ms. Olagi, we've been working diligently on this bill and on this draft. So you have a couple different options today. The staff recommendation is a watch on the bill. The staff recommendation would also be a watch on the bill if every single amendment that is enumerated in the RN is adopted. Why? Because there's things in there that we like and there's some things that give us pause. The reason I want to describe to you what these legislative positions mean in legislative speak and what you're going to be telegraphing, that is important. So there is one specific provision in here. If you look at the actual mock-up of the bill on page 5, if you go down to between lines 38 and 39, we had asked and introduced a new item. We had asked at the urging of your president that these candidates also pass the ADEX exam. Because even though there's a requirement in the bill on the back end that there be peer review of 10 cases every 6 months on the back end, it was important to us that we could not only verify the didactic education that they receive, but they have the actual clinical education and training to start treating patients on the front end. So we were able to graciously, and this is a public meeting, and there's a lot of people listening to this meeting, we greatly appreciate the addition of passage of the ADEX exam in the proposed mock-up. There's also a couple of provisions in here that Mr. Nelson enumerated that do give us pause. I just want to elucidate for everybody on that same page, on page 5 of the mock-up, between lines 29 and 30, it says, we've established a fee for these candidates. And the fee was originally $1,002. The fee also includes the cures fee, which is $15 a year. We, as the dental board, are the pass-through entity for the cures fee. We don't establish the fee. The fee in the program is administered by the Department of Justice. We're just the pass-through. So we felt strongly that we should not be responsible for collecting a fee that we have no control over. So the fee's been $15. If you do the math on that, which I'm not super good at, but I know 15 times 3 is $45. So we backed out the cures fee from the licensure fee, which is why it says $957. All of our fees are either in statute and are in regulation. And as Mr. Nelson likes to say, it's kind of like a menu at the restaurant. And it just says licensure fee, X, appetizer, X. So the language in this bill is a little cumbersome to me because it says that the fee shall be the lesser of $957, which is the fee, or the reasonable regulatory cost of administering the program. And that language really doesn't exist. The fees are assumed to be the reasonable workload cost of actually administering the program. So we have been trying to meet the author and the sponsor and their intent, which is to not do regulations on the bill. I would agree with Mr. Nelson that we will need regulations. It may not be voluminous regulations, but it's this sort of vagueness in the bill that we don't understand what it is that may precipitate regulations. One of the last things I'll say is on the intent language. If you go to page 8 of the mock-up, between subdivision O, after lines 13, there's intent language in the bill. Now, here's what intent language is. Intent language is not statutorily required language. It's not something that the board has to do, but for historical purposes and archivable purposes, it's basically the legislature saying, we would really like you to take this under consideration and please go about it this way. So intent language in a bill is not uncommon. So the intent language here says that the program shall be implemented within 6 months of receiving the amount of equal to or less than or greater than $200,000. So we can, board staff and the public, and for all the reasons that Mr. Nelson enumerated, we can appreciate this enthusiasm from the author and from the sponsors for us to implement this bill as quickly as possible. We get it. We understand it. However, this similar program has been on the books for 25 plus years. And the reason why, just to be clear, the reason why the program has not been implemented is not because the dental board, we have been dragging our feet. Not because we have been obstinate, not because we have this protracted regulatory package, not the fact that we have been putting all sorts of impediments into getting the bill implemented. The sole reason is because it was never funded. And implementation of the bill is 100% contingent upon philanthropic funds. And as Mr. Nelson enumerated quite well, the reason why the Physicians from Mexico pilot program finally got off the ground is because it was funded. So we have been taking a very serious look at this bill, not only from a policy standpoint, but for the ability of the dental board to operationalize it. Because with this intent language, we are of the opinion that checks are ready to be cut. We also understand, having talked with the sponsors of the bill, we're only talking about 30 dentists from Mexico. We understand they've already identified 18 candidates on day one that are ready to go. They felt it was important to put a specific dollar amount in the bill to implement the program. We don't disagree with that because, as you can imagine, there is a wide discrepancy between what some people think it costs a board to implement a piece of legislation and what it actually costs. So this is where kind of the horse trading happens. Most of the costs that we've identified in the fiscal analysis of the bill, it's $350,000. A large chunk of that is around the evaluation provisions of the bill. The mock-up that you have proposes to eliminate the evaluation program of the bill, which is something that the dental board would have to fund. If we're using the Physicians from Mexico pilot program as our muse, the medical board contracted with UC Davis to perform that evaluation. That was the justification for the medical board and the proponents of the bill to take their initial 3-year pilot program and extend it another 3 years. And now there is legislation pending to make that a permanent program. So we're kind of trailing behind what the medical board has done, and there's a lot of lessons learned there. And so from the physician side, it was a 3-year pilot program, which this is. They extended it another 3 years to make it 6. Now they want to make that program permanent. The reason why we came up with the fiscal analysis that we did is because we just don't pick those numbers. We spent, I don't know how many hours and days with board staff, with the fiscal office, doing what we call desk audits, trying to figure out what would be the workflow cost for us to implement the bill. That's how we arrived at our number. That's how we arrive at all of our numbers. If the evaluation program comes out, we think the $200,000 bogey in the bill makes sense. The reason why we had to come up with a number is because, and even though the bill will eventually be supported by the fees, the reason we had to come up with the number is because we needed to validate what size check needs to be written, right? And some think the bill will cost $30,000, so that's why that number is there. We appreciate that. The last piece that gives us pause, and Mr. Nelson mentioned this, is the language on page 8, subdivision P, sub 1, that says it's the intent of the legislature that the board administer the program without adopting regulations. Again, it's intent language. Nothing can prohibit the board from promulgating regulations. We also appreciate the enthusiasm of the legislature, not only the sponsors, to get the program funded, to get the program implemented, and to do it as quickly as possible. But nowhere in state law in our Dental Practice Act do we have similar language that says it's the intent of the legislature for you not to do something that you have statutory authority to do. So that's not like an insurmountable hurdle, but it gives us pause. And I'm just about to land the plane. I'm circling the airport one last time. With all of that being said, there are positive things in the bill. We've identified the need. We understand it. Access to care, as we talked about a lot yesterday, and as Dr. Thakur and Ms. Medina have spoken to with the Access to Care Committee, it is a major policy priority for the board. But also, Mr. Nelson mentioned our vision statement and the ability for us to provide safe care, because our number one mission is to protect the public, and we have to be able to operationalize the bill. So there are provisions in the bill that staff is recommending that we like, and that I hope we hear comments about positives that the board members like of the bill. There's also provisions in the bill that give us pause that we would prefer not be in the bill, that we have tried to negotiate and that we may continue to negotiate. And I hope the board feels every right to express those concerns as well. So that's why staff is recommending a watch. The last thing I will say is that in legislative speak, if the board chooses to take a support position on the bill, what that telegraphs is that the dental board unconditionally supports the bill, has no concerns with the bill, and will be urging the governor and will be sending a letter to the effect to the governor asking him to sign the bill. If the board takes an opposed position on the bill, the opposite is true. The opposed position suggests we completely disagree with the policy, and or the bill is completely non-operational, or there is some death knell provision in this bill that we just can't overcome. And if you adopt an opposed position, we would do the opposite. That suggests that there's no room to negotiate, that we're going to be sending a letter to the governor asking him to veto the bill. I appreciate the comments of board counsel. From a practical standpoint, here's where we are in the legislative session, and Mr. Nelson covered that very, very well. The last day to amend any piece of legislation on the floor is next Friday. No bill can be amended after that. The last day for them to pass any bills, the sine die, the end of the two-year session, is on August 31st. We've been negotiating amendments on this bill for the better part of 3 months, pretty extensively. I would suggest this draft, this RN that you have circulated, is probably what is going to go in the bill, and it is the best result from exhausting those negotiations. If you adopt a supportive amended or oppose unless amended, technically, I mean, yes, there is time, but from a practical standpoint, there is no time for us to further negotiate, get those bills in this sort of ledge council form and get those negotiated. Anything that the board may have concerns with, trust me, we've already kind of exhausted. So, with all that being said, I'm open and looking forward to the discussion. I appreciate the enthusiasm of the author and the sponsor to keep pushing the issue. I think it's consistent with what the board is trying to achieve and to accomplish. Commend board staff for spending an exorbitant amount of time on this issue. There are a couple provisions that do give us pause, which is why the staff recommendation is a watch. Thank you.
Thank you. Are there any other board discussion? Mr. David?
Robert David. Wow, there's a lot to this. And I would defer to my dental professional colleagues about a comfort level of the quality of care. I feel better about the ADEX piece. If these dentists are working, I assume they would be working under supervision at an FQHC. That makes me feel better. Well, then I want to hear from the dentists about this. I would prefer that we somehow signal support.
Yeah.
But if the staff, if their strong recommendation is a watch, I'd consider that as well. It sounds like the author's gone more than halfway on this towards us, and plus for access to care issues, I just think this is the right thing to do. Thank you.
Thank you, Mr. David. Let me just comment about your comment. I did ask about the supervisor or dental director, and apparently, because that would have satisfied a lot of my questions. But I was told that there was going to be no one supervising. And that's when I came up with a recommendation of the ADEX exam, because that's the minimum clinical evaluation that we can get to make sure that these dentists are qualified to handle, because I've been to ADEX exams and I know that it's, even the graduates from here have issues. So, and it's a little bit different in other countries. So I think that's the minimum necessary. And I did read the report on the medical pilot, the program that's already effective. The medical doctors that are here from Mexico, they had 6 months training apparently from UC Davis, where they had to go through classes before they could see a patient, an actual patient. And the dentists don't have that opportunity. They're not going to have any training. They're just going to come in with their skills that they already have, and they're not going to be evaluated in any way with no supervision. So at least I was recommending the ADEX exam would be necessary for these dentists to come in and work. I think Dr. Chan had
And
Dr.
could,
Chan? Okay. Dr. Forge, you'll be next.
thank you.
Okay.
First of all, thank you for the broader strategic game board in the legislature in implicating what we do and why we do what we do. So we appreciate that. Having that as an overview, there were a couple of elements knowing that this is one of our primary moves. So the first thing is that we should probably keep in mind that the FQHC is not exclusively for Spanish-speaking people. And yes, there's a provision there where there's choices of where to place these pilot people. And the background is that I did my training in South Central LA and realized that the population that were Spanish speaking were not from Mexico. They were not Mexican expatriates. They were from Venezuela, Colombia, El Salvador, Costa Rica. So we can't take the assumption that culturally it's the same thing as Mexico. It is not. The second thing is that, Brent, if you can explain what's the model of paying for this? Does the model mean that the philanthropic groups have to pay the entire fees and put it into an escrow account? Or is it pay as you go? Or is it a promissory note as we forward our funds first that they'll pay that back? I mean, there's different models of how that is funded. Go ahead.
Thank you, Dr. Chan. Just a comment on your first point. I appreciate that. And yes, it is the FQHC, the 3 million people in those underserved settings. They may not all be Spanish speaking, obviously, from Mexico. I think you're absolutely correct on that. And then also the other aspect of, well, how does this work? Because, it's being paid by philanthropic funds. And I always think when I was watching Mr. Rogers' Neighborhood as a kid, and it would be like, the Sears and Roebuck Foundation has made this possible. And I was like, well, thanks, Sears. But how is that happening? Like, how is the money coming into the dental board? The way that my understanding, and there's some finer details that we would have to get squared away, but my conceptual understanding is we would set up a separate account, and the money would come in from philanthropic sources, and that money would be used specifically for the philanthropic funding of the program. It's not coming from the state dentistry fund. It's entirely in its own separate piggy bank, so to speak. Now, I'm being very non-technical right now. And I see one of my colleagues, Mr. Wilbert Ramboa, standing up.
Sorry.
I don't know if you're fixing something or you're going to make a comment on a budget. You're doing both. Okay, well, I'm going to let Mr. Ramboa answer the question because he's actually technical where I'm non-technical on this.
Hi, Dr. Chan. Wilbur Rumbao, Administrative Services Unit Manager. So the technical terminology is the budget. We would work with the budget office to set up a separate fund. So the technicality is we have 3 funds for the dental board. We currently have the 0741, which is the dental board. We have We had 3142, which was the RDA program, but it's now rolled into 0741. And we have 3140, which is the loan repayment program. So if this were to go through, they would set up a separate fund, new number, and all the funds would go into there. And then you would see the fund conditions that we have in our report. We would have a whole different fund condition for this program.
So simplistically, do the philanthropic groups have to pay into the fund first before we implement?
That is correct.
Okay, so it's an escrow account.
It has to go into that fund first that has to be created by us. And then it would be, again, the budget office will work with the Department of Finance to create that fund.
Actually, that does make sense. Okay, so the next element was, part of the element is to have passing a certain score of TOEFL, the English language. So in one of the provisions, it talks about the California Dental Law and Exam. Is there a loop where we take the assumption that TOEFL is an equivalent to understand passing the California Dental Law Exam? Or does it have to be translated? That could be another linchpin.
As a point of clarification, you're saying, you're asking if the English testing is connected to what? To
Passing the California Dental Law and Ethics examination.
Yeah,
Yes.
Dr. Chan, my understanding, and board staff in the room raise a hand if I get this wrong. We're required by statute to provide our exams in English.
Okay, thank you, thank you. The next element was about having the point of contact with the program and a contact with one of the agencies in Mexico. Again, we're talking about different countries now that speak Spanish, and realizing that there are potential biases from one point of contact in Mexico versus the umbrella of Spanish speaking. So as long as we understand there could be biases through their lenses, that's another element. One of the other elements, and it had to do with conducting 10 secondary peer review randomly selected patient encounters, and then transmitting those records. Do we have questions of HIPAA and privacy with that?
Thank you, Dr. Chan. So your first question concerning the point of contact, the current RN that's on page 5 and line 22, it replaces representatives from California with the clinic, Clínica de Salud de Valle de Salinas, as the entity serving as point of contact. So you're right, like there is kind of a concern about, I suppose, the way people look at the program, but the FQHC is there. Once they're in the FQHC, they're not just serving, they're serving people that come into the FQHC, whether they look like me or you or whoever. So we're going to make sure that, the FQHC is the point of contact. So if that's helpful, it is in California. And then on the second thing that you said, where the peer review from one in California approved by the board to accredited by the commission or I'm sorry, you're asking about the peer review and whether or not there's a HIPAA consideration as to that. I used to work at the DOJ for 10 years. I'm not an attorney. I cannot give you legal advice. I'm also not a tax attorney, physician, and a number of other things. But I will say that in the context of my understanding is if the information is being used in a legal way by people who, and a lot of times, and I don't know the specifics on this, but like when my daughter was born at UC Davis, it was kind of these things like, would you like to consent to being part of this study? Would you like to, my understanding is there's points where you ask the patient, okay, are you okay with being part of this thing or not? I don't know specifically on this, but that is a consideration we can look into.
Looking for roadblocks ahead.
Yes.
So personally identifying information would be redacted in those peer reviews.
Thank you. 'Cause
Dr. Forge,
to come after us.
did you have a comment, Dr. Forge?
Yes, I do. But first of all, I want to know, can you see my hand raised from the room there? Does it
Yes.
come up? Oh, okay. I just wanted to make sure because I had it up
We
earlier.
had you. We had you. Thank you.
Oh, okay. My comment is this, is that I understand there's a lot of concerns about some of the regulations, but if we have it 90% done, why can't we take the position of support with amendments at this point? I know the staff recommendation is like watch because there's some concerns, those things in the way it's presented now that we don't like or there has some concerns in it. But I think if we show overall support for this, because there is a lot of things in it that we do like, and it seems like there's a lot of work that went into making it so that it could possibly pass. I just feel like at this point, there's a lot of support that we could show so that can get this going. That's my comment.
Thank you, Dr. Forge. Bryce Doherty, Executive Officer. The board, this is a staff recommendation. The board is free to take any position that you want on any piece of legislation that reflects your sentiment. I was only mentioning the amendment posture for purposes of what is actually doable.
And I
So
heard
if
that
the-
at the last minute, what you were saying too. There's only a few weeks left, and I know that you guys kind of worked hard, and it may not be doable since it's the 31st coming up. I don't know.
Yeah, and so that's my only caveat. If you take us, I just want it to be an informed position because we'll have to defend it. So if we take a supportive amended position at this point, I'm just realistically going to get comments that says, we're done with session. I don't even know if we can be able to get the amendments done, but if that appropriately reflects the sentiment of the board, we're going to do it, and we're going to see if we can thread the needle on whatever additional amendments you both want, or what the board wants. The other thing I'll say is I want to go back to Dr. Felsenfeld's comment. We're in this wobbler position. The proposed language that's been shared with you in the RN is not in the bill. I've been monitoring the assembly session as we've been meeting today. They're still in session. Upon adjournment of session, they're going to go into their respective appropriations committees and will be dispensing with the suspense file. This bill is on the suspense file. To get super wonky, the author's office has shared this RN with the appropriations committee and has asked that if the bill comes off suspense, it may not come off suspense. If it does come off suspense, the author's office is asking that they adopt these amendments. So we technically will not know if the bill gets off suspense, and if it does, if it gets off on a due pass as amended on an A or a B roll call, we won't know what the actual language of the bill in print will be until perhaps Friday, maybe early next week. So I think for purposes, and I appreciate all this discussion, this is what the public needs to hear, this is what staff needs to hear, so we can understand what your sentiment is. But you're free to take any position on any bill that you want. The reason we have a watch recommendation from staff is because the bill that's currently in front of you in print, we're recommending a watch position. We don't know if any or all or some of these amendments will be taken, and I would never recommend to the board that they take a position on a bill as it's potentially going to be changed. I've been doing this long enough. It's the third rule in lobbying that you learn, which is only take positions on bills as they're in print. So I'll just leave it there. But I don't disagree with you, Dr. Forge.
Mr. David?
Robert David. Perhaps we could follow the staff recommendation at this time and then delegate to the exec committee and the legislative committee if amendments are taken in the next couple of weeks, we could move our position to support, because you're right. If we wait until November, we might as well, So I would move such a.
Is there a second?
I think there's still more discussions to be, more.
Can you restate your motion, please, for clarity? Thank you.
that the Dental Board of California take a position on AB 1307 of watch at this time. However, if amendments are taken that satisfy the executive committee, that we move to a support position.
Is there a second? Dr. Chan? Dr. Chan, okay, we have any more discussion from the board? Dr. Thakur?
Yes, thank you, Dr. Thakur. So I have a question about page 4 of the bill, where it says all of the following taught by an instructor who's affiliated with the California Dental School, accredited by the Commission on Dental Accreditation. As the appears like this is added language, but who would be responsible? Would the dental board be responsible for doing this? Would this be a program that the students will go to at a dental school in the future, once accepted? But is this part of their 3-year program after they get hired at the, at the FQHC, and who kind of pays for it? Yeah, how is that going to be operationalized is a question. And I want to respond to Mr. David's question around supervision. We hire colleagues who practice, as an FQHC, we hire dentists who are fully licensed by the state and who are able to practice independently. We have mentorship and collaboration, but we're not supervising licensed dentists. That's one part of it. Supervision is only possible if FQHCs have a residency program. Some of us are teaching health centers. Some of us have affiliations with other health other universities like NYU, where we offer AEGD residencies. I am one of those sites. We offer supervision to an AEGD resident, but not to a licensed provider. Yeah, thank you.
Yeah. Thank you, Dr. Thakur. Actually, I had same comments too. Plus, on page 7, talks about work with the California Dental School to conduct 10 peer reviews, right? So I don't think we have the bandwidth, at least the faculty members at UCSF, because we are spread too thin, right? So if there's no buy-in from the schools before, I don't think any of us would be willing to go beyond our duty to get this done, because we have course directorship responsibilities, a lot of things going on at an educational institution. That's just my 2 cents.
I appreciate that.
And for Dr. Thakur again, for FQHCs, we do have a established peer review protocol and a process, which is actually quarterly, 5 charts, so it kind of matches. But then we're looking at more compliance review at our end if a school has to be now involved, and we have to share this outside because this is an internal process we use for QA/QI, and it's an established process, and with forms and everything. You bring a dental school into the picture, they want their form. That adds more administrative burden. In cases where we have residents, it's a little bit different because when there are disciplinary actions needed, we can collaborate with the program that we're affiliated with. And if we're a teaching health center, we've created those protocols internally. Here, it would be a little bit challenging. Not saying it couldn't be done, but it would be challenging, and it's a lot of administrative burden on the health centers.
Yeah, plus it'll cost money for the schools.
Thank you. I'll give you just a minute. Mr. Doherty wants to respond to Dr. Thakur.
Yeah, to quote the good Dr. Chan, there's a lot of moving parts on this one.
Yes.
To answer your technical question, Dr. Thakur, you mentioned all of the orientation requirements in the RN mock-up, hard copy on page 4, starting at line 40, all of those specific things that need to be taught. I want to back you up to the page prior to that, page 3, at the start of that subsection. So if you go to page 3 of the mock-up, subdivision 5, on line 27, it says, "The applicant has satisfactorily completed an orientation program approved by Clínica de Salud," specifically, in connection with the licensed physicians from Dentists from Mexico pilot program that includes all of the following components. And what I negotiated was, as opposed to referencing, these were provisions that were in the original pilot program. The original pilot program was physicians and dentists, licensed physicians and dentists from Mexico. The programs have since been broken out. So the original legislation included all of these orientation provisions. And as opposed to, as a matter of legal reference, as opposed to referencing a prior statute, the original language that was under discussion was an orientation program as approved by, XYZ bill in XYZ year. I asked that those specific topics that would have to be instructed by Clínicas be specifically enumerated in the bill. So it would only, those instructional requirements would be a requirement of satisfactory completing an orientation program approved by Clínica.
Thank you, Dr. Gruel.
So it would be approved by Clínica, but not a CODA accredited dental school, or that.
Correct, nor by the dental board, because we've been trying desperately to not trigger regulations or extensive regulations, and we've been trying to keep, and I want everybody to understand this, everybody who's listening, we've been trying to avoid the need for regulations, and we've also been trying to minimize the actual cost of implementing the program. And if the dental board was responsible for the orientation program, we would probably need voluminous regulations on how we to oversee that and implement that, and penalties with failure to comply, and how do they comply, and hiring consultants, and it would make the bill pretty cost prohibitive. So we're kind of trying to do both at the same time.
Thank you, Madam President. Gray Wall, a board member. My main concern is with the clinical competency for that, like Dr. Loren mentioned, amendment number 14 passed the ADEX dental examination. Is it a possibility, or how it's going to work how we vote on watch or support position? ADEX examination. We need to have some kind of successful completion of ADEX or any other equivalent standardized clinical examination.
Yes. So the ADEX is contemplated as one of the amendments that is in the current version that's being looked at. And that has been added to kind of hopefully address that concern. And so we don't know for sure if that's going to be included or not. We know that with this current version that the sponsor and author are okay with that. And we certainly love that idea. But we don't know if it will be in the final version or not.
So I guess your question is, if we go into a watch position, how can we ask them, have
Well,
support?
Go ahead.
Yeah, Bryce Doherty, Executive Officer. That's why this discussion right now is important, because if the motion that's on the table is adopted, the board will be taking a watch position, or actually reaffirming your watch position, because the bill was amended from the version that it was in when you took a watch position. So we actually exercised that interim authority of the executive committee after the bill was amended in this current form to stay in that watch position for purposes of allowing these negotiations to unfold. So I know this has been a laborious agenda item. I think I've flagged that for everybody today. The reason why it's important for all of us, again, to hear all of the concerns, both positive and negative, is because if the motion is adopted and the board adopts a watch position on the bill, pending what amendments are taken, and deferring that to the executive committee, we would certainly, as a matter of protocol, consult the Legislative and Regulatory Committee, which you sit on. But I think since we do the public's business in public, it's important for us to hear that there are members of the dental board that believe that the ADEX exam being included in that draft is a critical element if the board was to consider a support position on the bill, if I've correctly characterized that. Okay.
Is there any other board discussion?
No, just a question. A no vote on the motion as currently proposed would, if that's sustained, it would default then to our previous position. Is that correct?
This is Bryce, Executive Officer. The current position on the bill is a watch. The reason we're bringing the bill back to the board for consideration is because it has changed significantly, almost completely rewritten since the last time you took a watch position on the bill. And the last time you took a watch position on the bill reflected all of the amendments we negotiated on the bill as it left the assembly. So what staff is really asking for is, and maybe board counsel can weigh in here, the current position of the board is watch. Given the sensitivity of this issue, my preference, I don't know if it's a legal requirement, my preference, given the hour and 15 minutes that we've already spent on this, is for the board to either reaffirm that position based on the language that's in print, and also with the caveat and instructing board staff in conjunction with the executive committee in consultation with the legislative and regulatory committee, the motion on the table, to change that position based on what amendments might be taken. So just for clarity, it would provide us better direction. If you're maintaining a watch position, I'd leave this up to board counsel. If you're just going to stay in a watch position, I don't know if a motion is required.
So if you are going to stay in a watch position, you don't need to take a motion on it. However, if you do want to express an opinion one way or the other regarding the changes that, even though they're not official, they're pretty close. And at the very least, if you want to express the board's opinion regarding what you think of these, especially with regard to the edX examination, you would need to do a support to say, hey, thank you very much for including this. We like it. This is what you have to do to kind of send that message of,
Would the watch position take care of that?
no.
Oh, so you have to change it to a support.
So I agree. Okay, so just before Bryce jumps in, I agree with your position. I understand why you're recommending a watch. But maybe there's somewhere we can meet in the middle in terms of, yes, we're doing a watch position on this, but we just want to officially send you guys a letter saying, hey, thank you for adding the 8X. We agree with this, we agree with this, we agree with this, just to kind of put it out there, because they have done a lot of work on this, and I do think it is,
Continue.
good.
I think we have a motion and a second. We need public comments. Do you have any public comments on this topic? No? So, okay, we need to open the WebEx, please, Mr. Moderator, so we can continue with public comment.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen. Or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. So we'll go now take the vote. Mr. Dearkin, Board Secretary, take the vote.
And I.
Oh, that might be a little.
Point of information, I have a question. I think you're saying two things in there, John. We're voting on a position to watch this bill and not and support if amended. The watch is to see what happens with it, and then with consultation and the executive committee, they will make the decisions as to what to go from there. But not to say, to tell them to go to support if amended. Let's watch what's going to happen to this bill And I would also suggest, as long as I've got the floor, this is okay to do this with all due respect to council, because you watched a bill last time that was not a bill that we liked at all. It was sort of, had a lot of questions. A lot of those questions, it's now a new bill. It's a new bill. What do we want to do? We still want to watch it because we have a few little tweaks we'd like to see, and we have to then decide if the tweaks don't come in or do come in, where do we want to go from there? And that's why we're going to leave that to the executive committee.
Okay,
So
so,
I would vote yes on this.
Mr. David,
Clarification that we're voting on just to watch.
Mr. David, could you repeat the motion?
I'll take the amendment. I mean, my
Amendment.
initial motion was to accept the watch position and to defer to the executive committee to if proper amendments were taken, to take a support position. But if your preference is to leave that discretion to the executive committee, I'll take the amendment.
Okay.
Let me see if I can help. So you're moving to, or this is how I would possibly adjust this. So it would be take a watch position, and under the board's administrative manual, the executive committee can continue to work with the author's office on making any additional amendments that the board has indicated that they're interested in. But keep the watch. And then there's 2 weeks left. If anything interesting comes up that the board would need to chime in on, again, in theory, you could schedule another meeting to discuss it, but at least put it, do a watch position and just continue to allow Bryce and his team to do what they've been doing to get the bill potentially either where it needs to be or to be okay with it as it is.
What I don't want to have happen is to have to confer, the whole board have to confer again on this bill. I'm trying to defer to the executive committee on if we need to take a different position.
Yeah.
Bryce Doherty, Executive Officer, just being the tip of the spear on this, I just want to make sure whatever is proposed and whatever is adopted by the board reflects the sentiment of the board. Otherwise, we will have to have an emergency meeting in as little as 3 or 4 days to take a position. So what I am hearing is the board would like to reaffirm the watch position, but if all of the amendments, if all of the amendments that are included in this mock-up are adopted, then the board would like to move with the interim authority, with the executive committee, move to a support position. Is that what you're saying?
That was my initial.
In its entirety, or just including ADEX, or it's in its entirety?
I think where I was trying to go is if, in the opinion of the executive director and the executive committee, if the bill has, if amendments are taken that satisfy the executive committee and the executive director, that we would move to a support position.
Member Yu, yeah, personally, I think that to take a position motion for watch, but then if you want to just leave everything to the executive committee without involving the board, I will be a little concerned about it too. So just a simple watch will be the best.
The other element.
Mr. David, please repeat your motion so we can take a vote. What is your final motion?
The other element is that the other side could come up with something as a counter also.
Well, yeah, we'll have the executive committee to look at that.
This is Bryce Doherty, Executive Officer. I'm not suggesting this is happening, but I will suggest it. This is the last 2 weeks of the legislative session. So I suspect everybody is watching and listening to this meeting right now and trying to see what the disposition of the board is on the RN and the mock-up. And depending upon that disposition, may determine whether or not they take the amendments, which amendments they take, or if they do not take them at all. So that's why I strongly recommend that the board only adopt official positions on bills that are in print. We are doing an extraordinary courtesy to the author and to the sponsor and everybody who cares about this bill, with the permission of the author, to share a document that is not public, that tips in and suggests to you what the author is comfortable with including in the bill. But I'm also telling you that we don't control the legislature, and I have no idea what amendments are going to be taken. So I believe you can take a watch position, and the discussion that we've heard, which this is a publicly recorded meeting, the concerns and the positive and negatives that we have heard, I think would be able, the executive committee in consultation with the legislative committee would be well informed on which direction they would like to go. I will also tell you that the caveat of the board administrative policy and procedural manual not only gives the executive committee the interim authority, but once that position and decision is made, we are required to let the board know immediately. So if you get that information, I would send that out to you immediately saying this is the position that was adopted. If the board felt otherwise or had concerns, like Dr. Yu mentioned, we could call an emergency meeting.
Okay, Mr. David, please state your motion, final motion.
Oh, no, I was just gonna agree with the executive officer.
Okay,
So
thank you.
I don't have any legal concerns.
I agree with the watch position, but as Dr. Or Mr. Daugherty, he mentioned that, we can change the watch position to support. But I think we should have an emergency meeting because I really feel like input for the whole board is important in order to change the position from watch to support.
Thank you. Mr. David?
My motion is that on AB 1307, the Dental Board of California takes a position of watch and defers to the executive committee if that position needs to be changed as a result of negotiations with the legislature.
Are you okay with that? Is that Dr. Chan? Yes? Okay, so now a public comment? Okay, any comments via WebEx? Moderator, please open the lines for comment.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. Let's take a vote. Mr. Dearkin.
I will just correct it because it's agenda item 24 instead of 23. Otherwise, great job on trying to keep up with all the
We use a,
subsections.
Mr. David already stated the motion. Is that okay? We do not repeat it. I think everybody heard it. We can take a vote.
And let's see, we're on a board that knows how to untie our tongues. Aye.
Chang, aye.
David, aye.
Felsenfeld, aye.
Forge, aye.
Zareen, aye.
Dina, aye.
Olagi, aye.
Takur, aye.
Favorably no. You aye.
Thank you. We are going to take a 5-minute break. We'll be back very soon. Noon. Hi, everybody. We're back. Just to note that Mr. Chen and Mr. David have left the meeting, but we still have a quorum. So, Mr. Brandt, you can continue, please, with your
Thank you, Madam Board President. I'm on page 169 of the board materials. We're at agenda item number 24B, Roman numeral 3F, SB 758 by Senator Umberg, Public Health Nitrous Oxide. This bill is something that prohibits retailers, particularly those holding tobacco product licenses, with exceptions for grocery and general merchandise stores with grocery departments and convenience stores in some contexts, from selling nitrous oxide at retail locations to curb recreational misuse. It expands existing tobacco licensing laws to treat such sales as a misdemeanor violation, while authorizing local ordinances for stricter rules that do not restrict legitimate uses, such as dentistry, food preparation, and automotive services. The bill preserves access for professional and medical applications. There is a kind of an issue with teens, young people using whippets, which is kind of the street slang that I'm not too familiar with, about, huffing these things and going out and having car accidents and all sorts of terrible outcomes. And so this is kind of something we're seeing as a trend in the legislature. The staff recommendation on this bill is support, because we don't want nitrous oxide misused. The bill has a carve out for dentistry, so it can still be used in dentistry. So the staff recommendation is support, and an action is requested.
So you're asking for action?
Yes.
Okay. Do we have a motion? Dr. Felsenfeld? We have a first and a second. Dr. Gruel, second. Do we have any board member discussion? Any in-person comments?
I have one board member, Vader Hobley. So what happens to the existing inventory then?
I don't know. Maybe they can sell it to the dentist. I don't know. Probably not, because they're called. So here's the thing. It's called Galaxy Gas, and it comes in these really. You go on Amazon right now, and you can pull up a big container of it, and it's colorful. It doesn't look like the stuff you buy for your dentist practice. It's marketed and intended to appeal to teenagers the way like a vape product would or something. So I don't know what happens to the inventory.
Any other board member discussion? Any public comments? Seeing none, do we have the WebEx open, please, Mr. Moderator, DCA moderator, so we can get public comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. Now, Board Secretary, please take the vote.
Thank you. This is agenda item 24B, moved by Felsenfeld, second by Grewal. Motion is to support the staff recommendation of support SB 758 nitrous oxide restrictions. Chan?
And I.
Chan, aye. Chang is absent. David is absent. Deerking is aye. Felsenfeld? Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Grewal?
Grewal, aye.
Grewal, aye. Ladin?
Ladin, aye.
Ladin, aye. Medina? Medina, aye. Olage?
Loggy eye.
Olage, aye. Takur?
Thakur, aye.
Vader Hobley?
Vader Hobley, aye.
Aye. And you?
You, aye.
You, aye. The motion passes, Madam.
Thank you. Mr. Brandt?
Thank you, Madam Board President. The next bill is item G, SB 1314 by Senator Minjavar. This bill is titled Cigarette or Tobacco Product Retailers, New Retail Locations, and Sale of Nitrous Oxide. Another nitrous oxide bill. This bill would impact retailers of cigarettes or tobacco products by prohibiting new retail locations within a 600-foot radius of schools or daycare centers. Effective July 1st, 2027, with local jurisdictions able to set greater distances. It also bans smoke shops from possessing, storing, owning, or selling nitrous oxide or related paraphernalia, with civil penalties and potential license suspension revocation for violations. Grocery stores would be exempt from the bill's provisions. So this is another bill kind of addressing the same problem of nitrous oxide misuse. Staff recommendation is support, and action is requested.
You motion to support.
Second.
Felsenfeld, Dr. Yu first, Felsenfeld second. Do we have any board member discussion? Seeing none, do we have any in-public comments? Seeing none, moderator, please open the WebEx for online discussion.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. Board Secretary, please call the roll.
Thank you. This is agenda item number 24-3G, moved by you, seconded by Felsenfeld as stated. Chan?
And I.
And I. Chang? Is absent. David is absent. Deer King? Yes. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Grewal?
Grewal, aye.
Aye. Larin?
Larin, aye.
Larin, aye. Medina? Medina, aye. Olage?
Olage, aye.
Olage, aye. Takur?
Thakur, aye.
Aye. Bader Hobley?
Bader Robley, aye.
Bader Hobley, aye. And you?
You aye.
You, aye. The motion passes.
Thank you. Mr. Nelson?
Thank you, Madam Board President. Moving on to our final bill, and this is information only. SB 1445, which is item H here, by the Committee on Business, Profession, and Economic Development. This is a healing arts omnibus bill that's authored by the committee. The bill acts as a legislative cleanup vehicle, bundling technical and non-controversial changes for multiple professional boards into one package to simplify the legislative process. So this bill really helps us out. It contains helpful cleanup items. And here's a quick summary of what's in this bill. BPC 1621, it removes old references to the portfolio examination that's been repealed by the sunset. BP 1632.6 repeals outdated references to the portfolio examination. BP 1724 removes the application fee for the portfolio examination. And finally, BPC 1750.1 corrects dental assistant duties inadvertently changed in the sunset. So just a sunset cleanup bill. And with that, thank you so much for your patience and have a wonderful day, as we say in Sacramento.
Thank you, Mr. Nelson. Appreciate that. A lot of work. Okay, so now we'll move on to agenda item 25, 2027 meeting dates, page 212, 218. We have Mr. Bryce Doherty, Executive Director, to present this agenda item. Thank you.
Thank you, Madam President. Bryce Doherty, Executive Officer. In the memo in your board packet on page 212 is the proposed meeting dates for 2027. Three caveats that I would like to mention with regard to these meeting dates. You'll notice that we pushed back the first meeting of the year, proposed pushing it back from early February to early to mid-March. The reason why we're recommending that is because the bill introduction deadline is typically the third week towards the end of February. Most legislative bills will be heard the end of March, but principally the month of April. So with our meeting in February and then again in May, we missed that critical window of taking positions and being able to weigh in on legislation and end up having to kind of play catch up. So the recommendation of staff and the executive committee is to push that meeting back to early to mid-March, which would be a Thursday, Friday. Also, one of the deliverables and objectives of the Legislative and Regulatory Committee is to have institute a legislative day. The thinking under development is that we would do a legislative day on Wednesday, March 10th, the day before the first day of the board meeting. We would have board members come in early whom can participate. We would do a ledge day from about 10 to 4. We would break up into 3 or 4 groups of 3 people, provide you with materials, talk about board priorities. So I just wanted to note that. Typically, we meet 4 times a year. We like to have at least 3 months in between board meetings. As soon as this board meeting is done on Monday, we're going to be starting to put the agenda together for the November board meeting. This doesn't just come together on its own. So the timeline between the March and the proposed June 10th, 11th meeting is the 3-month window. the time between June and August is obviously only 2 months, and the last meeting is being proposed for the first week in October, October 6th and 7th, which is a Wednesday, Thursday. Reason why that's being proposed is we had presentations from the American Association of Dental Boards yesterday and ADEX. They are going to be doing their national meeting in 2027 in Chula Vista down in San Diego. And so it was the admonition of the executive committee to take full advantage of that meeting and participation from California, since we're somewhat the host state. And so that's why October is being proposed. There's also sentiment in general, having just taken a straw poll, that board members do not want to meet in the month of December. So that's why this calendar, if adopted, we're starting later, we're ending earlier. And I'm just telling you that the August board meeting is probably going to be pretty light, because we only have, 4 weeks to turn around a meeting. I will make a note, though, that in the second paragraph of the memo, pursuant to Business and Professions Code Section 101.7, the board is minimally required to only meet 2 times per year, once in Northern California, once in Southern California. This tight turnaround between June and August makes me a little nervous. If we were for some reason decide not to do the August board meeting, that would leave us March, June, and October. That would give staff more time to have a more robust meeting and agenda, but these dates are being proposed for the board for consideration.
Thank you. Do we have any comments from the board? Discussion? Any in-person comments? Moderator, please open the lines for public comment.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen. Or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. We will now move on to item number, let's see, what are we?
I guess this is Bryce Doherty, Executive Officer. We don't need a motion on adoption of the dates, but we do need consensus. So the supposition here is, since nobody commented pro or con and the dates have been presented and we're moving on, that these will be the dates for 2027. Thank you.
Thank you. Okay, agenda item 26, future agenda items and next meeting dates, page 2019, Mr. Doherty.
Good morning again. Good afternoon. Bryce Doherty, Executive Officer. The worst time to speak is before lunch and before adjournment of a meeting when people have to catch flights. So I will be brief. I do want to report out under this agenda item that at our last meeting in May, under this agenda item, you, Madam President, asked the board staff about what can be done regarding establishment of a retired license status designation for those licensees who are no longer practicing. Since then, board staff have been working with the Department of Consumer Affairs Regulatory Council to start drafting regulatory language to establish a retired licensure status category for all board licensees. This would include dentists, registered dental assistants in extended function, orthodontic assistants, and any subsequent permits affiliated with those licenses. Board staff anticipates bringing this regulatory language before the board for consideration and action at the November meeting. Secondly, yesterday, under agenda item 12B, the board heard an overview presentation on the board's diversion program and its purpose. Based on the subsequent and robust discussion and questions, board members can anticipate a follow-up presentation at the November meeting from the program vendor Premier Health Group on their role in our diversion program. Board members will also hear personal testimony from a recent program participant about their experience in the program. Future meeting dates, the next and last board meeting of the year for us will be on November 5th and 6th at the Department of Consumer Affairs headquarters in the first floor hearing room, which is located at 1625 North Market Street in Sacramento, California, 95834. Thank you, Madam President, and that concludes my presentation on this agenda item.
Thank you. Appreciate.
Sorry, Mr. Doherty, did you say the 5th and the 6th of November?
Correct.
I'm sorry, I'm looking at 20.
Do we have any board member discussion on this item? Any other board member discussion? In public comments? Hello. With the bottom.
That button. That button. Gary Cooper, representing California Academy of General Dentistry, CAGD. And we would respectfully request the opportunity in November to make a presentation to the board on behalf of the CAGD. The future president of the National Association is Dr. Bill Kushner, and he will be here to make a presentation. And we'd like to discuss how we may be able to be involved in the access to care issue that's so very important and that we heard significant information about yesterday. So I am respectfully requesting that hopefully on the agenda in November, we will be allowed to make a presentation on behalf of the CAGD.
And Dr. Guy Atchison, a representative from the California Academy of General Dentistry, previous president. There's so many new board members now that I think this is really an important time for us to establish the one organization that represents general dentists, especially when we're talking about access to care issues for the rest of this year. Thank you.
Thank you very much. Appreciate your comments. Anybody else would like to speak from the audience?
Sherry Becker, representing the Alliance. I've been too quiet this whole meeting, so I would like to request on the agenda an update on the RDA position that's been open on the dental board to be put on the agenda, please. Thank you.
Thank you. Appreciate that. Any other in-person comments? How about WebEx comments? DCA moderator, please open the line for comments.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please use the raise hand icon on your WebEx screen, or if you're an audio-only participant, you may press *3 on your device. Instructions will be displayed. I do not see any requests for comment. I will turn the meeting back to you.
Thank you. Mr. Doherty would like to make a comment.
Yeah, thank you, Madam President. Just a point of personal privilege, while we've been in this meeting, I've also been monitoring the legislative session today. And moments ago, the Assembly adjourned, and our sponsor bill, AB 1760, was concurred in the Senate amendments with the unanimous 63-0 vote, and that bill is now on its way to the governor's desk for signature. We'll do a full report in November. Thank you.
Thank you, everybody. We are now on agenda item 27, adjournment. Thank you, moderators, staff, and assistants for your meeting today. This concludes our August 12th, 13, 2026 quarterly dental board meeting. This meeting is adjourned. Thank you, everybody, for being here.